On August 26, 2025, Cleveland Police Detective Donald Kopchak was indicted in the Medina County Court of Common Pleas on 2 counts of abduction, 1 count of ethnic intimidation, and 1 count of assault. The charges arose from an incident on April 26, 2024, at the Buzzard's Roost Sports Bar in Hinckley Township, Ohio. Kopchak was also a deputized agent on a Bureau of Alcohol, Tobacco, Firearms, and Explosives task force at the time of the incident. The case was handled by the Medina County Prosecutor's Office and tried before Judge Joyce Kimbler. On March 30, 2026, a jury found him guilty on all counts. What you are about to watch is Kopchak's sentencing hearing, and later in this video, the body camera footage from the night this all started. For over 30 years, I sat on the bench. A badge gives you authority within the law, not outside it. When 2 officers are off duty and drinking, they have no more authority than any other person in that bar.
Thank you. You may be seated. We are here on the matter of State of Ohio versus Donald Kopchak, case number 25CR0520. Mr. Kopchak is present in court with his counsel, Attorney Spellacy. We're here today to impose sentence pursuant to a jury verdict which was adopted by the court of guilty of 2 counts of abduction, each felonies of the 3rd degree, 1 count of ethnic intimidation, a felony of the 5th degree, and 1 count of assault, a misdemeanor of the 1st degree. Present on behalf of the state of Ohio is
Mr. Salisbury, Judge.
Both, Judge.
all right. Attorney McNamara and Attorney Salisbury. Mr. Salisbury, are you speaking on behalf of the state?
Yes, Your Honor.
Okay, do you have any recommendations?
Yes, Your Honor. You heard the trial, so there's no need to belabor the facts. As I said in the Mr. Lajak sentencing, this is a crime that kind of divided the community, very impactful, we believe. We believe the jury got it right. And quite frankly, as the court shall recall, didn't take a very long time to deliberate even. The impact on the victim was great, and although that impact was so great, he still to this day is saying he doesn't want anything bad, see anything bad happen to these 2 guys, which is kind of amazing to me, considering what he was put through that day, both physically and mentally now, as you heard his testimony. The defendant, in my mind, has still not taken responsibility, although he does say he does never deny doing anything. I don't believe that's true. You'll recall his testimony. I don't believe he did admit to all the physical aspects that he did to the victim, but you know, I'm not saying he sat there and denied doing anything. He didn't. And again, he thought he was justified in doing so. That belief was clearly wrong, and is clearly found by the citizens of Medina County not to be tolerated. Judge, this was a clear case of ethnic intimidation. We believe a prison sentence is appropriate, and we would leave that length of which in the court's discretion.
The victim in this case is Jonas Bakradingil, a commercial truck driver from Texas, a legal immigrant from Eritrea, and a United States citizen who has been in this country for 14 years. On the night in question, he was at the bar alone, minding his own business before a morning delivery. Kopchak and a second off-duty officer, Daniel Lajak, confronted him, demanded identification, took his wallet and phone, and physically removed him from the bar. Kopchak then pinned him to the ground in a leg lock until police arrived. Under Ohio Revised Code Section 2905.02, abduction occurs when a person, without privilege to do so, removes another from the place where they are found by force, or restrains their liberty under circumstances that create a risk of physical harm. That is exactly what happened here. And under Ohio law, when an offense is committed by reason of the victim's national origin, it is classified as ethnic intimidation, which is what elevates this from a simple assault to a felony.
Legal. Okay, legal.
I know you're illegal.
Sir.
All right, let him go. You stay on the ground. Stay on the ground.
Oh, okay.
Just sit there.
Yes. They don't let me call police. They took my everything. I'm good. I'm legal. Everything. This is my ID.
He's from Israel. He got a Texas ID. Came in.
Where do you live, partner?
I'm living Fort Worth, Texas.
You live in Texas?
Fort Worth, Texas. Yeah.
Okay. What are you doing in Ohio?
Came into work.
Work where?
Where am I?
Yeah, where do you work?
I'm truck driver.
Where's your truck at?
I just park it in
Where?
on the company. I have delivery for Monday.
Okay.
I just want to be here, and I have to go to the motel. When I'm coming here, these two guys, when they see me, they ask me like a lot of things, and they take my ID. Why you here? I don't know why. He just take my hand like this, just like I don't know why. I'm trying to call police. He took my phone, everything. These two guys, they ask me a lot. You are not supposed to be here. This is fake ID. I'm not fake. I'm legal in the United States. I've been here 14 years. I'm citizen.
I told these guys like over here, I go, guys, you're off duty. You're in a bar drinking. What are you doing?
Police were called to the bar for a disturbance and found Kopchak holding a man on the ground in a leg lock. They ran his identification, valid commercial driver's license from Texas, American citizen. On the recording, Kopchak and Lajak identified themselves as DEA and ATF agents and told officers they believed the man was a terrorist. They were not federal agents. They were local officers assigned to federal task forces. The incident prompted an FBI investigation. The case was transferred to federal prosecutors in Detroit to avoid a conflict of interest. But after more than 15 months, they declined to bring charges with no explanation. It was the Medina County Prosecutor's Office that ultimately took the case to a grand jury.
Mr. Spellacy?
Thank you, Judge. Also with me is Lewis Group, Your Honor, and Ms. Hanson is also sitting back there. Judge, obviously I filed a sentencing memorandum with you on June 9th. I believe I'm confident the court got it, read it. There's some great letters attached. I think they describe Don very, very accurately and very well. This is a tragic situation, obviously, for everybody. And I would disagree with Mr. Salisbury that my client he testified to what he did. We can go over the spilt milk, so to speak, but there wasn't a justification instruction. There wasn't an expert report that was submitted. But that's for a different day, Judge. But I think that could have changed the outcome substantially. Judge, I can just say that in the brief, he's a father. He's a good father. He was a coach. He was a good coach. He was a police officer. He was a good police officer. And I think a lot of these people behind me would support those contentions, Judge. He's been in jail 82 days. They have not been an easy 82. I think the pre-sentence report indicates his likelihood of recidivism is at a score of 1. So I don't think that we need to protect the public from him. And I think the odds of this happening again are extremely unlikely. Judge, I think all those things speak to a community control sanction, and that's what we're asking you to do here. Thank you.
Thank you. Mr. Kopchak, what would you like to say on your own behalf?
Again, I just want to go off exactly what my lawyer just said, that I never denied anything. I took the stand and I was honest, and that's what I was told to be. I was told to be honest by my lawyers and my union, and that's what I did. I sat there and I was honest, and never in my life did I ever think that I would be here sitting in front of a judge like this, and that's not the type of person that I am. And those letters and everything that are put in front show that what I've done in my life and what I've would continue to do when I'm out. And on behalf of my lawyers and everything, I was advised to keep this to basically that.
Kopchak's attorney asked for community control, essentially probation, pointing to his record as a father, a coach, and a police officer, and a recidivism score of 1, the lowest possible. Judge Kimbler's response was direct. Her focus was not on whether he is a good person, but on his behavior and its impact on the victim. Mr. Bakrdingil testified during the trial that the incident left lasting trauma. He does not sleep well. He does not feel comfortable. And despite everything, the prosecution told the court that he still does not want to see anything bad happen to the men who did this to him.
Well, Mr. Kopchak, I have read the sentencing memoranda. I have read all the letters in support. The thing that the letters in support don't discuss is the effect of your behavior on the victim in this matter. And so my focus is not on whether you're a good person, I'm sure you're a fine person, but on your behavior and the impact that that had on the victim. And so after consideration of all the relevant factors set forth in the statute, and also the information contained in the pre-sentence investigation report, it is the sentence of this court that on count 1, a felony of the 3rd degree, you will have 18 months in prison. On count 2, also a felony of the 3rd degree, you will have 18 months in prison. On count 3, a felony of the 5th degree, you will have 10 months in prison. And on the misdemeanor of the 1st degree, you will have 120 days in jail. Your time will run concurrently and not consecutively. Upon your release from prison on counts 1 and 2, you will have a mandatory period of post-release control of between 1 to 3 years at the discretion of the adult parole authority. When this period of post-release control is imposed, if you violate the terms of that supervision, the adult parole authority is authorized to return you to prison for up to 9 months for any single violation, up to a maximum of 50% of your prison term for all violations. If while on post-release control you are convicted of a new felony offense, in addition to being punished for the new offense, the judge could add an additional consecutive prison term of 1 year, or whatever time remains on your post-release control term, whichever is greater. As you will be incarcerated, all fines and costs will be waived. Also, on count 3, the felony of the 5th degree, you may be subject to a period of 2 years possible discretionary post-release control. I also need to notify you of your appellate rights. You have the right to appeal the conviction or sentence in this case. You do that by filing a notice of appeal with the clerk of courts for the Court of Common Pleas within 30 days of this sentence.
Those sentences run concurrently, meaning he serves all of them at the same time, not one after another. So his actual time behind bars is 18 months. Under Ohio law, the judge could have given him anywhere from 9 months to 36. One more thing, a felony conviction in Ohio means you can no longer carry a firearm. For a police officer, that is the end of a career. His co-defendant, LeJack, took a different path. He pleaded guilty to a reduced charge and received 90 days in county jail. Kopchak went to trial and got 18 months in state prison.
I'm going to make an oral motion for a stay of the sentence on behalf of Mr. Kopchak. There are a couple matters with respect to that. For a stay motion, there are basically 2 considerations. The first is the same kind of bond considerations the court would normally consider when releasing somebody pending a trial. I'm going to defer to the court on those. There's already been a personal recognizance bond. If this is granted, that would be appropriate. I have no reason to believe that there's anything that's changed simply because Mr. Kopchak has been convicted. He's the same person before you. Same family, same considerations. He's not a flight risk. As to whether or not a stay should be granted, the general standard applied by the Court of Appeals across the state of Ohio is whether there's a reasonable argument for appeal. The court referenced numerous times in the transcript, which I've now read in the last couple of days, that there could be an appeal, likely would be an appeal. There were a couple issues. I'm happy to address the specific issues pending appeal if the court would like to get into that, but I think that given all that has happened, it's probably safe to say the court understands the issues from the trial, and we would just say that there are reasonable grounds for appeal. Coming out of today, if the court could issue a ruling on this in writing in the sentencing entry, that could avoid a written motion, but I'm also happy to brief it in writing for the court. It's up to the court. Please let me know what the court would prefer from me going forward from here, but that's the motion, and thank you for your time this morning for that.
Thank you. Your oral motion is denied. Your client has filed motions with this court in which he has indicated that he would prefer to be in prison rather than remain in the Medina County Jail. And so I am going to grant him his wish and let him go to prison at this time.
May I be heard on that, Your Honor?
No.
Okay, thank you.
Thank you. Anything else on behalf of the defendant?
No, thanks.
Anything else on behalf of the state of Ohio?
No, Your Honor.
Okay, thank you. We are in recess.
After sentencing, the defense asked for a stay pending appeal. Judge Kimbler denied it and told Kopchak that since he had previously filed motions saying he would rather be in prison than remain in the county jail, she was going to grant him his wish. A badge is a responsibility, not a license. If there's a case or courtroom exchange you want me to break down, drop it in the comments below. If this is the kind of breakdown you're here for, like and subscribe so we can keep building a more informed audience.